really honored to be here and to have this presentation regarding the judicial review in the European Union. Basically, I want to continue on the presentations held yesterday regarding the special character of the EU, and we heard from Professor Grazer and from the others, of course, that the well-known fact of the sui generis character of the European Union is certainly something that should be respected. But I wanted on this wave, how to say, to regard the question of judicial review, judicial control of its acts regarding some basic human rights issues. For example, we all know in the because I teach public international law, and I will focus in one part of my presentation on the international treaties and the international rules, that we all know that the international organizations do not enact binding decisions. We have two exceptions of Security Council resolutions based on Chapter 7 of the UN Charter, and of course the EU, which brings acts which are obligatory to member states. So the question of judicial review at the level of international organizations, by my personal opinion, had to be mostly developed at the level of the European Union. The two ways two main ways how the acts of the European Union can be reviewed, can be controlled, of course, one is the action for annulment of the acts of the European Union, and the other are, of course, the preliminary ruling procedures. I will focus later on the international treaties regarding the European Union and on the most famous decisions in Yusuf and Kadi case, and regarding the basic human rights issues in the European Union. So basically, it is, by my personal opinion, undisputed that now the Treaty on Functioning of the EU and the Treaty on EU and the Lisbon in general has the constitutional character. Maybe we can discuss this issue later on during the debate, but even the European Court of Justice of the European Communities has confirmed that in its early practice. And after the historical development of the European Union, I think it is undisputable. Of course, the treaty establishing the Constitution for Europe has been rejected, we all know. But my personal opinion is that the Treaty on Functioning of the EU has kept many of the prerogatives from this treaty, except the notions, the terminology, and so on, but that we have the system here which is most likely, or which is very close to be a constitutional system like in the States. Nevertheless, I will not say that the European Union is a state. It's an international organization without any doubt. It may strive to become a state, a confederation. We heard that yesterday during the discussions, but I think that now it's not the time, and who knows, it will be in the future that the European Union will grow into something more coherent and to become a state. I'm not such an optimist, or I'm not sharing these ideas. Of course, one aspect of judicial review is to control the acts which were brought by the institutions themselves. Because we all know the acts that are brought on the level of the EU, we all know the power of these decisions, the impact, the direct effect, and so on, and it would be, I think, unconstitutional if we don't have an instance that will control or that could control this kind of decisions. If we leave that to the states, of course, and that the Court of Justice said, we will have the problem of different implementation and different understanding of the norms of the EU. So basically, the European communities and later the EU had to establish such kind of judicial review. We all know about the creative and pro-European attitude and position of the European Court of Justice, and it's still ongoing issue. So basically, it was not a surprise that this kind of judicial review has been introduced. of course, the action, as I said, there are two ways, the actions for annulment, and we all know the reasons and the deadlines and so on. And one major step has been made in order that the individuals have the stronger or easier way, easier path to annul and to ask the annulment for the annulment of the acts by casting the personal interest from the Treaty of Lisbon, so that is that they only need to prove their direct interest by the certain rule, by the certain act of the EU. Of course, also mentioned yesterday during the presentations the issue of the rule of law, and also it was from the 70s, from the practice of the Court of Justice of the European Communities, it has been said that the rule of law is something that the Court of Justice should emphasize and should take care of that. The other, I will not stick so much to these issues about the forum, about the ways of annulling the acts and so on. But we also have the preliminary ruling procedure. Professor Varga also mentioned yesterday about how the courts of the lower instance in Hungary ask for preliminary rulings in order to, how shall I say, avoid decisions of the Supreme Court or in some kind of a revenge to the Supreme Court of Hungary, how they do it. But that's also one of the important tools how to review the acts of the European Union in order that the system should be coherent. My opinion is that that's the only goal, that we achieve the rule of law and that we achieve that there is an instance that can control the acts that are brought. And I emphasize once again these acts that have very strong impact on the life of every individual or legal or legal person in the European Union. This issue of indirect control and preliminary ruling is of great importance, because the deadlines are not here so strict. I mean, there is no deadlines, and it can be used later on. I will now focus, if you allow me, to the issue of the international treaties and their relations to the European Union. Of course, in Europe, dominant is monistic doctrine, that the international law is a part of national law, and now we have a problem. What is the European Union legal order? What is the EU law? Is it international law? Is it national? I cannot say, of course. And is it sui generis? Which means, should the EU law have the primacy over the international law, over international rules? For example, we all know that the EU is concluding international treaties, and there was an issue in several cases in which the European Court of Justice should decide on the, if I can say, legality, or whether these international treaties are in accordance with the EU law. And what the e.g., what the European Court of Justice has done, it has separated this decision, the decision about in order to conclude international agreement is separate from the decision of the European Union and the international treaty itself. So basically, in the procedure before the Court of Justice, there was an issue of questioning, of reviewing the act which led to conclusion of an international agreement. So basically, if the Court of Justice has refused, if it would refuse to control the legality to conclude an international agreement, then I think if it avoided judicial control, I think it would seriously impact its whole system, its whole legal system, and I think that this legal construction had to be made in order to preserve one aspect, to preserve one aspect of the control of the acts. Regarding the other issue, and that's the position of Security Council resolutions, very important, very interesting issue, especially after September 11, and regarding this Committee of Sanctions and Security Council resolutions which were affecting human rights of persons connected with Taliban movement and Al-Qaeda. And we all know that Security Council resolutions have been enacted according to the paragraph, chapter 7 of the UN Charter, and really it was a big international legal issue whether those decisions can be controlled, reviewed. Who would review the acts of the Security Council? The International Court of Justice didn't have this jurisdiction, it still does not. National courts, of course, it would be difficult to apprehend this kind of control, but in the cases of Yusuf and Kadi especially, and it was dealt. I'm sure that most of you know the facts, and so I will not repeat. But we all know that even the Court of Justice of the EU, I mean, 2 instances have not been in accordance what to do with this resolution, because the European Union adopted a regulation based on the Security Council resolution, and according to that regulation, it had a list of persons, and their property has been deprived or freezed and so on. And there was an issue whether the Court of First Instance, General Court, can annul this regulation. And the Court of First Instance said, no, this regulation is just transposing the Security Council resolution. It invoked the Article 103 of the UN Charter, the supremacy of the UN Charter over other obligations, and so on. And the Court of First Instance didn't have the courage, my personal opinion, to do that. However, the Court of Justice, the second instance, had said that regulations which were enacted on the basis of some international document, or in this case, a Security Council resolution, can be subject to a legal review, and they can be annulled. This case, by my personal opinion, of course, it is the old one, but it states also in favor of the European Union wanting to become a complete system, a full constitutional system with all checks and balances, as we heard yesterday with the issues of federalization and so on, and also with regard to the legal review and the constitutional aspects. I'm not sure that we will have constitutional complaint or procedures like before constitutional courts in the member states, but as we see from these examples, the European Union wants to have something similar. If you allow me, because of the time, I would just briefly go or mention this issue. Maybe some of you will say it is closed issue, but also linked with a legal review and judicial review. That is the question of European Court of Human Rights, European Convention, and the possible accession of the EU to the European Convention of Human Rights. Many of you will say it is closed question. It shouldn't be open, but I think that the question of human rights, individual fundamental rights and human rights, is very important, and it's becoming also more important, and that's one aspect of the EU law or should be also focused on the possibility to have another instance which could control EU acts. So basically we all know the opinion of the ECJ, we all know that there are some, of course, procedural obstacles, but in my personal opinion, the issue that we have another instance, that we have European Court of Human Rights, which could challenge, which could decide on the decisions of the EU regarding, of course, the European Convention of Human Rights, would be an additional contribution to the individual protection of human rights. Maybe now the conditions are not ripe yet, but who knows in the future? I think it should be regarded. Maybe with Brexit, maybe something changed, maybe with some other issues in the Council of Europe and so on and so on. Maybe this question could be, if I can say, revised again. So I would like now to finish my presentation and to say as a conclusion that I think that the process of judicial review is very important for the European Union. It's still in progress, and I think it's on us to monitor that process and to see whether in the future, together with other issues like federalism, constitutionality in general, how it will affect the future situation in the European Union. Thank you. Thank you very much.